The European Court of Justice. That's what I want to talk about in this video. So, let's get started. Hi, I'm Mark. Welcome to my channel and welcome to another episode of European Union Explained. Today I want to talk a little bit about the European Court of Justice. To give you some more information, I prepared a few graphics for you, so let's just have a look. The Court of Justice of the European Union, the ECJ. Its tasks are to ensure that EU law is applied in the same way in all EU member states, ensuring that countries and EU institutions comply with EU law. Who are the members? There's, first of all, the full court. That's one judge from each EU country plus 11 advocates general. And this, let's say, simple court, which deals, you see later, with the minor stuff. That's 47 judges. This number will increase to 56 in 2019, 2 judges from each EU country. It was founded in 1952, and its location is Luxembourg. The Court of Justice of the European Union issues EU law, ensuring that it is applied in the same way in all EU countries. It also decides on legal disputes between national governments and EU institutions. In certain cases, individuals, companies, or organizations may use it in a dispute with an EU institution if it believes it has violated their rights. The tasks of the ECJ. The most common cases are interpretation of the law or preliminary rulings. National courts in EU countries must ensure that EU law is correctly applied, but interpretations by national courts are not always consistent. If a national court has doubts as to the interpretation or validity of EU legislation, it may ask the ECJ for clarification. In the same way, it is possible to check whether a national law or administrative practice complies with EU law. Then there's enforcement of the law or infringement. Lawsuits against the administration of an EU country that does not apply EU laws, that's one possibility. Such a procedure may be initiated by the European Commission or another EU country. If it turns out that the country is wrong, it has to remedy the situation immediately. Otherwise, it may be fined in a second case. Then there's the cancellation of EU legal acts or actions for annulment. If there is reason to believe that an EU act is in breach of EU treaties or fundamental rights, this can occur. Such a claim may be filed by the Council of the European Union, the European Commission, or, in some cases, the European Parliament. Individuals can also bring an action for annulment before the court to annul an EU law directly affecting them. Another task is ensuring EU intervention, or actions for failure to act. Parliament, the Council and the Commission must take decisions in certain circumstances. If they fail to do so, other EU institutions or, where appropriate, individuals or companies may lodge a complaint with the ECJ. Punitive measures against EU institutions or measures for damages are another task. Individuals or companies whose interests have been damaged as a result of acts or omissions by the EU or its employees can turn to the ECJ. What's the composition of the ECJ? The court is divided into 2 courts. It's the full court, or the high court as I call it here. It deals with requests for preliminary rulings by national courts, certain actions for annulment and appeals. And the smaller courts hears judgment on actions for annulment by individuals, businesses, and in some cases EU administrations. So in practice, it deals mainly with competition law, state aid, trade, agriculture, and private labels. Each judge and advocate general is appointed by the national government for 6 years. Re-election is permitted. In each court, the judges will elect a president for a 3-year term who can be re-elected. What's the working method of the ECJ? For each case, a judge is appointed, a so-called rapporteur, as well as an advocate general. The cases are dealt with in 2 stages. First is the written procedure. The parties involved submit a written declaration to the court. Comments can also be added by national authorities, EU institutions, and in some cases individuals. The judge, the rapporteur, summarizes this in a report which will be discussed at the General Assembly of the court. There it is decided. How many judges are charged with a case? Well, it's 3, 5, or 15, which would be the entire court, depending on the meaning and complexity of the case. Most cases are handled by 5 judges. The entire court is rarely dealt with. They also decide whether a public hearing or oral proceedings must take place and whether an official opinion of the Advocate General is required. In an oral hearing or public hearing, the lawyers of both parties can present their comments to the judges and the Advocate General. The latter can ask questions. If the court has decided that an opinion of the Advocate General is required, it will be presented a few weeks before the hearing. The judges then discuss the verdict together and issue it. The lower court's procedure is similar, except that only in most cases only 3 judges are involved and the opinion of an Advocate General is dropped. So that's all I wanted to tell you about the European Court of Justice for today. I hope it was interesting enough for you and you learned a little bit more about the European Union. I thank you for watching. If you haven't done so yet, please don't forget to subscribe to my channel. And by the way, I don't mind if you like or share my videos. But for now, have a nice day and see you soon.